Okay, fantastic. Welcome everyone. This is the Train the Trainer session for the Comprehensive Ethics Training course. My name is Kate Ashworth, and I am the training associate here at the Commission on Ethics and Lobbying in Government. We will be joined today by Megan Hennigan, who is the Deputy Director of the Commission, as well as Brianna Neal, who is the training assistant here at the Commission. And the three of us are here to introduce this new training course to you. Now, this particular version of the course that we're going to be reviewing today is now known as the full version of the CETC. One of the things that you will notice as we are rolling out various changes for this training program is that we are going to be posting several different versions of the CETC. The changes in Executive Law 94 requires live ethics training, and this course does satisfy that requirement. The other course that is required under the new Executive Law 94 is an online ethics refresher course that will be done in the off years when you're not completing this live course. So because there is only one live course, there is only one CETC. However, we do recognize that applying the CETC to the entire state workforce isn't necessarily going to be the best fit for all employees. Certain parts of this course apply to some employees more than others, particularly, for example, information related to financial disclosure forms. So what we are doing is today we're going to present the full version of the CETC. This is the version of the course that most closely matches the CETC version that you are most recently familiar with. This version of the course covers all of the material of all the aspects of the public officers law. So it's the largest, broadest version. It is suitable for anyone who needs to complete live training. However, we also will have a version like we did before for those who are not state employees, but they are unpaid or per diem officers, so UPOs. We call that version of the CETC UPO, for those unpaid per diem officers. We just finished revising that course content, and that I believe just got loaded to our website very recently. So if you do have board members who are not state employees, but they are unpaid or per diem officers of various boards, councils, commissions, authorities, etc., then you can use the CETC UPO to do live training for that specific population. And it's only good for those people. It's not good for the rest of the employees, but UPOs. We also have a third version that we just submitted to be added to our website today. That third version is for non-filers. I see that there's a couple of people who have already just asked, will there be a separate training for filers versus non-filers? Yes. So for non-filers, that course is called CETC-NF for non-filers. And this version that we're going to be presenting today is the CETC full. It's the full version, and by that we mean it has everything and the kitchen sink. It has all parts of the public officers law included. So that is the course that is suitable for your financial disclosure filers. So the full version for FDS filers, NF for non-filers, UPO for unpaid per diem officers. For now, that's where we're going to keep things, but we are open to the possibility of creating new versions of the course depending on how things develop. So with that said, we do have all of these courses, or will have all of these courses and a full complete set of trainer notes posted to our website. As I said, I just sent the training materials off to be posted, but it sometimes takes a few days. So certainly by next week, all of the course materials will be online. And one final note, we also have a new version of the plain language guide posted, or it will be posted soon, to the Ethics Officer Info Center in the education section of our website. That's where, in the Train the Trainer section, that's where all of our course materials are posted. We took a while to get the plain language guide updated, but it is now updated and available with one difference. The plain language guide we had previously required or strongly suggested that all participants receive a copy of the plain language guide. We do still strongly urge all employees to receive a PDF copy of the plain language guide. However, we're not going to mandate that or require it because we are aware of the fact that some of your employees may not have access to computers or may not be issued an agency email address that would make issuing a PDF difficult for those populations. So so plain language guide is there and available. We encourage its use. It's just no longer mandatory. Somebody just asked, for employees, would they, if they watched the recording, would that count? No. Live training has to be conducted with a live trainer. The definition of live, as interpreted by our commission and the predecessor commission, live training means a live trainer who is able to respond to questions in real time. Your participants have to be able to ask questions in real time. However, here's the hitch: you don't have to have answers immediately available. That's an impossible standard. Sometimes people will ask you questions that simply do not have an answer in the immediate moment because ethics is so situational. Sometimes you have to look into things and get back to somebody with an answer. So the person who is conducting the training for this course does not need to be specifically knowledgeable about the public officers law. The trainer notes that we provide are meant to be a guide for new trainers who are unfamiliar with this material. And if a participant asks a question that the trainer is unable to answer from the materials that we provided, then those questions can be referred to either the agency ethics officer or to our commission. Our Attorney of the Day program is always available for employees who have questions about how the laws may impact them. All right. So this course is available or applicable for everyone. And so one of the things that we also say is that if it's going to be too complicated for you to sort out which of your employees are filers and non-filers, and you're not sure, or you're going to have a class with mixed employees, some who are filers, some who are not, then this course today is the course that you should use for them, because this is the course that will be applicable to all. So with that said, let's get this party started. You will notice that if you're familiar with the former CETC, this is what I will draw your attention to. As I said, the public officers law has not changed, so the content remains the same. However, what we have done is we have reorganized all of that content. So things flow differently. We've rearranged topics and grouped them in different formats for you. So that will be the main thing, the main thing for you. All right. We have a basic disclaimer here, and we always encourage you to include this disclaimer. The disclaimer says, that this is not intended to construe as legal advice. And this is also a good point, though, for you to remind your participants that you as an agency may have additional policies that are more restrictive than the rules that are contained in this course. So that's the main takeaway there. Now, here's where you get to see the list of topics and the order in which we now have the CETC organized. We do start with a commission overview like we did previously, especially now that we're a whole new commission. I think it's helpful for participants to know who the new Ethics Commission is. This version of the CETC does include an overview of financial disclosure rules. So if you are giving this to a mixed group, when you get to that point, you can certainly tell people that, this part only relates to filers, and, just so that people who aren't filers aren't too confused. Then we have a chapter of this course that is all about conflicts of interest, and this is where we're going to review the Code of Conduct in Public Officers Law 74. We have a whole chapter dedicated to outside activities. We know that that's a huge topic, and it really did deserve its own chapter. And for sure, one of the things that I should mention is that we do encourage you to add slides that have agency-specific policies or information. And you can insert those slides either at the beginning of each of the appropriate chapters or at the end of the appropriate chapters, however that suits your flow best. Or you can put agency policies right at the beginning of the training or right at the end of the training, depending on depending on how you like to do things best. But we do encourage you to add slides, but please do not delete slides, hide slides, or change the content of slides. And that's really important. That's because we do feel an obligation to make sure that there is some degree of consistency across the state workforce, that everybody is at least getting the same something when it comes to ethics training. And we can't control for that if you're modifying the content on the slides. So go ahead and add agency-specific slides, but please do not hide, delete, or modify the information on the slides that get packaged up and delivered. All right. After outside activities, we talk about things of value. This is where we'll talk about gifts and honoraria and travel reimbursements. Then there's the Little Hatch Act, where we cover politics in the workplace. Whew, how about politics? Then we will talk about post-employment restrictions. That's such a big topic. It's such an important topic. So we have a chapter there. And then we end with just kind of a reminder to the state workforce that we're all in this together as far as improving ethics and accountability for the state workforce. So that's the flow. And let's see if we can get going. Oh, sorry, my page advance buttons have moved in webinar. So there we go. So commission overview, who are we? Because we don't have an acronym right now, we're still being known as the commission or COLIG, but we were, this is new commission as of July 8th, 2022. That's when this new Ethics Commission Reform Act took effect. But the scope and jurisdiction of the commission remains the same. So we really do still have jurisdiction over the whole universe of state officers and employees, elected officials, candidates for those offices, legislative members and employees, certain political party chair people, and the entire universe of lobbyists. So our mandate is huge, really. It's, oh. Okay, so what changed for the commission? There's a number of things, and if you haven't been reading up on the press, then let me just give you a few updates. There have been changes to the number of ethics commissioners who run the Ethics Commission. There are now 11, so a few fewer. They're now appointed by more political leaders. So the state comptroller and the attorney general now have the power to name commissioners to the Ethics Commission. But all of those nominees are now vetted through an independent review committee that's made up of the deans of all of the New York State law schools. So all of those nominees get put through the law school ringer, and those who are approved get appointed. Those who do not get approved go back to their nominator to make a new nomination. Another big change is that the commission can now act on basic simple majority vote. Before, under JCOPE, there was some complicated voting rules that were highly criticized. Now it's nice and super easy, simple majority vote. And finally, the other big change is that the Ethics Commission is now both subject to FOIL and the Open Meetings Law. So those were some of the criticisms about JCOPE that have been remedied in the new legislation. But the commission's primary functions remain the same. So, we're usually referred to as the ethics watchdog, and that is true as far as it goes. But investigations and enforcement are really only one small part of what this commission does. We do oversee all of the regulations for both ethics and lobbying, but a really primary part of what we do is to give advice and guidance and education to those who are under the jurisdiction of the commission. So we've got a lot of balls in the air there. All right. This slide hasn't changed much. One of the things you'll notice, though, is that we've moved a lot of the text off of the slides and into the trainer notes. That is just to follow the principles of good, clean design, to eliminate visual clutter, but it does mean that the trainer notes become more important for you as you become familiar with the materials, all right? But the purpose of ethics training hasn't changed. It's to raise awareness of what the laws say, to prevent any potential conflicts of interest in the state workforce. And of course, the purpose of ethics training is it's a matter of law. We have to do it, right? All right, so here are what the new ethics training requirements say. I outlined it a little bit at the beginning, but the law in Executive Law 94 Section 8 is where the training requirements are found. So it says that that everybody shall complete live training within 90 days of hire, and then every 2 years or every other year thereafter. So the CETC satisfies that live interactive participatory question. And sorry, I'm hoping that Megan and Brianna can answer some of the questions in the text chat, because there's quite a few of you asking questions that I'm kind of talking right over. So, but the CETC is the primary course. It's the only course that's required now to be live, so that's why it is only that. The ethics seminar course has gone away. There's no longer an ethics seminar course. There's also no longer the OEO, the online ethics refresher course. Those two courses are now obsolete and unavailable. We've taken them down off of our website. The second course that's required under Executive Law 94, Section 8 is the online ethics refresher course. This course is under development, but not yet ready. We do hope to have that course available and online sometime early in 2023. So those will be the two courses. The upside of this is it's going to be easier to explain to people what the training requirements are. That every 3-year thing was a little bit weird, but now you just tell new people, well, you have to take a live ethics training course and you have to do it every other year. And in the off years, you're going to be taking an online refresher course. So that's what the new training requirements are. All right. Agency ethics officers, we are elevating you. So many times we've learned from experience that people said, ethics officer? I didn't know we had an ethics officer. Who is my ethics officer? What do they do? So now we have a slide where if the ethics officer is the one delivering it, you can introduce yourself, you can pat yourself on the back, you can take a bow, or you can complain about how overworked you are. All of them are perfectly legitimate, right? I know you are. So we give a brief rundown about who the ethics officer is and what the main tasks of the agency ethics officer are. But this is a good opportunity for you to be able to give any contact information for your ethics officers when you do it. All right. Oh. Yeah, all right. Then we move into the attorney of the day. This information was usually provided in the CETC, and again at the end, we do still have an attorney of the day program, but please note the email address for the attorney of the day has changed with our commission change. It used to be legal, now it's guidance. So guidance@ethics.ny.gov is the email address for our attorney of the day program. Our phone number has not changed. Okay, so with that said, that's just the brief commission overview. We tried not to spend too much time on that. Now, this is the version that includes information about financial disclosure statements. So if you have a mixed group of people and some are not filers, you can just merely at this point say something along the lines of, here's information about filing financial disclosures. This may not apply to all of you, but it may at some point, so listen up. All right, this material has not changed substantially. We start with who's required to file. And really the two most important things are policymakers and threshold filers. That's going to be your target audience there. Policymakers are an agency determination. So your agency determines which job titles are considered policymakers. So you may have to field some inquiries from your employees. I'm not a policymaker, I have nothing to do with policy. So you might have to field that. Threshold filers are those people whose salary exceeds the salary threshold that triggers the need to file. And that salary threshold is CSEA salary grade 24. And that's the threshold whether or not anyone is a member of CSEA or any particular union. That's just what the benchmark is. So the salary threshold, the current salary threshold did just change. It's now currently 105,472. So the people who your FDS filers are either going to be policymakers or threshold filers under those terms. So this is where you can explain that. Why file financial disclosure statements? This really is for transparency, and because we are held to public standards of accountability. Right? We serve the public, we are accountable to the public. And so if you're a policymaker or you exceed a salary threshold, then it is thought that those employees deserve to be more accountable to the public by filing financial disclosure statements, which are designed to prevent conflicts of interest for that employee between their outside interests and their state employment. So that's the whole point of filing financial disclosure statements. Now, what is disclosed? There are, depending on your audience, you can either go through these bullets or you can just say, make a general statement that what is disclosed are many aspects of your finances, the ways that we obligate ourselves financially. Whether or not you drill down and explain every single bullet, I leave that to your discretion. You will know your employees and your audience best. Filing deadlines. For most people, for most agencies, the filing deadline is going to be May 15th. For those of you who are working at SUNY or CUNY schools, you may in fact be juggling two different deadlines. There is a separate November 15th deadline, primarily for SUNY or CUNY professors, because May 15th is right in the middle of finals and graduation and things. So the large majority of people have a May 15th deadline unless you're a SUNY or CUNY professor. And then please note, if you are a human resources person or you're doing this training for new hires, brand new FDS filers generally have 30 days from their time of appointment to get their FDS in for the previous year. So that might be something that you need to raise to a group of new hires that are getting this class. Sometimes people get concerned about their privacy because financial disclosure forms are technically a publicly available record. They are requestable. So if your FDS is requested, the name of minors are redacted, home addresses are redacted, and they don't even have to name the specific location of property that's listed in the FDS form. And those are automatic things in place to help ensure privacy of people. All right, so people sometimes get a little concerned about that. But there's also other options. Again, these things haven't changed, but filers can request to either redact or not answer certain questions on their financial disclosure form. If they have a specific privacy concern, they can make those requests. They're not granted automatically. They have to get weighed against their reason for the request versus the public's right to know. But there are mechanisms. If you have an employee who has some specific concern, you can let them know about that. Filers can also request an extension of time to file. If they can't get their filing done on time, they can request an extension. And if they're a threshold filer, they can also request to be exempt from the filing entirely. This option is not available for policymakers, only for threshold filers. And all of those forms are available on our website for anybody who is interested in filing an extension or exemptions. For those people who drop the ball and forget to file their financial disclosure forms, a number of things happen. The first thing we do is we'll reach out to a filer and we'll say, hey, did you forget something? We'll send a friendly letter. They'll have 15 days. It's a 15-day letter. They'll have 15 days to correct their filing or get it in. If they still fail to file their FDS, then we have to send a notice of delinquency, which goes to the agency and the filer, and notices of delinquency are posted publicly on our website. So that should be emphasized for filers because that's very good incentive to get their filing in on time. We don't want their names to be associated with a non-compliance issue on our website. But please do encourage filers to reach out to the Commission if they have any questions or problems or concerns with filing their form. We have filing specialists who are very friendly and knowledgeable and would be more than happy to help a filer understand what their obligations are and help solve whatever problems they may have. All right. So then we move on to conflicts of interest. This is the Public Officers Law 74. And so for that, I'm going to pass the ball over to Megan, who is going to take this section of the course. And I'm going to start jumping into the chat and I'll see if I can answer any questions there.
All right, everyone. So hello and good afternoon. I will first tell you all that I was supposed to be at the office today in front of a camera in my office. However, as a parent, a lot of you may know that your best laid plans often don't work. So not only do I have a child with a possible stomach bug, but also a concussion. And thus I am home today and holed up in a corner of my house doing this, but that's fine. I kind of feel like the grand and almighty Oz of ethics land. But you can, we'll just go along here. So I'm going to start talking about conflicts of interest in Section 74. The one thing I will also say is my laptop is somewhat, doesn't have all the functions of the WebEx at home. So I will be asking Kate to say next slide. So don't be distracted by that. All right. We'll jump into 74. And here what you'll want to let your audience know is this is a section of the law that will cross through almost any other topic that we talk about today. So when we talk about outside activities or gifts, really almost anything, we need to think about 74, where we're thinking about actual conflicts of interest between your personal interests and your public job, but also the appearance of a conflict can also be an issue. So those are two things to make sure to emphasize when you're teaching this course. And let's get into the next slide, please, which is the general rule. And I'll read this briefly. New York officers and employees and members of the legislature and legislative employees shall not have any interest, financial or otherwise, direct or indirect, or engage in any business or transaction or professional activity, or incur any obligation of any nature which is in substantial conflict with the proper discharge of his or her duties in the public interest. And what all that means, again, is separating your personal interests from your public state duties. And another point to emphasize here for your state officers and employees is personal interest is not only your own personal interest, but it can be for the benefit of someone else, like a friend or a family member, or even a preferred vendor that you like working with a lot. All right, so let's go to the next slide. When we go through these 9 standards of conduct in Section 74, we'll be addressing these major themes of impartiality, confidentiality in your state job, the misuse of state resources. There are a few standards that deal with financial conflicts of interest, and also maintaining public confidence in public integrity. All right, so the next slide, please. For all of those participants today who have taught this over and over again, what I want to let you all know is these used to be about probably 9 to 10 slides, all of the standards of conduct. We did one each individually and had an example. What we've done here is to group it all into one slide. So the training notes, once you receive them, you'll see are very long. It's all the examples, but we cut the slides down. And as Kate said at the beginning, we don't want you to delete any of the examples, but what I've found is it's often a good idea to maybe add one that involves an example that might resonate with your particular audience. So put in an example, if you're teaching auditors one day, put something in that they might respond to from circumstances from your own agency. That's a good tip. All right, so we're going to breeze through these. Standard A is standard regarding impartiality. You cannot let your outside job impair your independence of judgment when performing your state job. Our example, you're a state employed engineer working on a contract with a private sector vendor. And as a state employee, you're responsible for making sure that vendor is adhering to your agency's contract. The vendor offers you a part-time position on a completely different project, not the one you're working on. That does not involve your agency. Standard A means you cannot, as a state employee, pursue that outside employment because it might look like you are not being impartial. All right, the next two Standards B and C are regarding confidential information. B is about not disclosing confidential information you have access due to your state employment. And C is about not disclosing confidential information to actually personally benefit yourself or someone else. The example we have for both B and C is you work as a child protective manager for OCFS and have access to Connections. Connections is a confidential database of child abuse and maltreatment investigations. You have a good friend who is a non-custodial grandmother of a child who is a child abuse victim. And when asked by your friend, you disclosed information accessed through that confidential database, and you gave that information to your friend's grandchild. Well, that would, hopefully that did not happen. That would be for sure a violation of this particular standard. Standard D is about misusing your position or the state or the resources of the state. And it prevents you from securing unwarranted privileges or favors based on your state job. And it also has a part of it is regarding the stewardship of state resources. So not using resources of the state for your personal business use. Example we have for D is you're an employee at a state agency and you have your own desktop publishing business. You would not be able to use the state agency's scanners or printers, computers, so on, to perform services for your clients. All right. Standard F is regarding doing business with the state. This is about you cannot contract for work with an entity that is licensed or regulated by your agency. Our example, you work for DOH and we have Acme Hospital who's regulated by DOH. You would not be able to contract for work with Acme. The next standards are financial standards, E and G. E is abstaining from transactions with any entity in which you may have a direct or financial interest. The example we give here is you work for ITS in the procurement department, and it's where there's purchasing computers for the state. You would not be able to participate in a decision to purchase computer equipment if, for example, your spouse worked for a company that was bidding on that purchase. The other financial conflict is in G. G is about abstaining from personal investments that conflict with your official duties. Here we have an example. You work for the Gaming Commission, which licenses new casinos. You have information that a certain casino company will soon be licensed in the state, but then you realize you have an opportunity to make a profitable investment in the casino before the licensure is publicly announced. Using that sort of what we call insider knowledge would not make that decision something you could do, in a violation of standard G. All right, the last two standards are F and H, and these are also known as our integrity standards or our public optics test. Now, if we can go to the next slide, we're going to talk about these briefly. So as public servants, state employees, we're held to a higher standard of integrity and conduct. Standard F is talking about avoiding situations that may suggest improper influence over you in your state job. So don't act like you can be influenced. If it looks like you could be improperly influenced, that is enough to violate this standard. And H is about avoiding conduct that may suggest that you have violated the public trust. We must not act in ways that give the appearance of misconduct. If it looks like it may be suspicious, don't do it. So this is what we were talking about at the beginning of this section, that even the appearance of a conflict of interest could be a problem. And that's where we find it in these standards F and H. Now, these two do not carry a monetary penalty if you're found in violation. There is a new change in the legislation, though, that if it comes to us and we have found that this commission has found that an officer employee has violated F or H, I believe that we can then refer that to the agency now for follow-up for whatever disciplinary action that the agency may want to take. Okay, so Code of Ethics, that was a really fast run through. Most of you already know all this. Again, we've just kind of clumped it all into one or two slides. It's all the same information, and you can add more if you feel like that's a good decision for your trainings. All right, the next slide is about personal business with the state. This is under Public Officers Law, Section 734. This is the rule saying that a state officer employee cannot contract with any state agency for the sale of goods or services if it's more than $25, unless there's public notice or competitive bidding. The next slide is under 73.7, and this is talking about representation before the state and certain prohibited communications. If you have an outside activity as a state officer employee that involves an appearance before a state agency, you cannot be compensated for that particular appearance if it's in connection with this laundry list of various things, which include real estate transactions, rate-making proceedings, adoption or repeal of regulations, obtaining grants or loans, licensing or permitting, can't be a paid lobbyist, and finally, cannot be paid for an appearance against the state in the court of claims. The next topic in this conflict of interest section is nepotism. And I think what a lot of people are surprised to find out, and again, many of you have already taught this, and now that it's to a much broader audience, this might be one to really drive home that these rules are not only applicable to if you're involved in a decision regarding hiring or supervising or disciplining a blood relative, but the definition of relative in the public officers law also extends to anyone who is living in your household at the time. And that could mean so many different things, right? If you have a boarder or a roommate, it does not have to be a blood relation. If you're involved in a decision regarding any of those things, that could be a possible violation of the public officers law and the nepotism rules. The next slide is regarding the reverse two-year bar. This is about the rule regarding when it affects former private sector employees coming in newly into state service, someone coming in and recusing themselves from matters directly involving their former private sector employer. This comes from an older advisory opinion. I believe it's 9809 for any of you who want to actually look it up. But I have been getting a lot of questions about this lately, so that is a good one to write down if you need it, 98-09. General rule is if an employee is coming in from the private sector and there is a matter regarding their private sector employer, they should be taken off those matters for a period of 2 years. And its purpose is to prevent you from giving preferential treatment or to be unduly influenced by your former private sector employer. And as any of these topics come up, again, just what Kate and I say a million times through when we train this is call your ethics officer, and make sure that they know that the ethics officer is there to take these questions about all these various sorts of issues. The next topic we're diving into is outside activities. All right, the next slide will go past the header and will be on what is an outside activity. An outside activity is any activity or obligation completely unrelated to your state employment. And of course, it cannot occur during your regular work hours or use state resources or conflict with your state job. And as I mentioned before, this is where we talk about Public Officers Law 74. does it conflict? Is there a conflict of interest with that outside activity and the person's public job? Then it's likely not going to be okay to take. The next slide, so entitled General Provisions. Here's a place where you may have to, depending on the makeup of your audience, you may have to tell your folks, hey, some of this applies to you, some of it doesn't. So the regulations are only going to apply to policymakers. I'll get into that in a second. But 73 is going to apply to everyone. So those topics that we just ran through, restrictions on selling goods or services, certain paid outside activities, and prohibiting state employees from lobbying, though does not matter if you're a policymaker or a threshold filer or whatnot. Those are across the board. However, the regulations apply to policymakers. In the next slide, we'll get into a few of those certain rules. Policymakers have to come to the agency for certain outside activities when they're making between $1,000 and $5,000. And as all of you know, if it goes over $5,000, not only does the policymaker have to come to the agency, they also have to now send that for approval to my agency. And the form, the commission's outside activity approval form, is online. The next slide, we're just talking about, we usually have, I think in the plain language guide, I'm not sure if it's still there, but we have a nice little chart that goes through all of these particular areas where policymakers absolutely have to come for approval. Certain outside jobs, business ventures, if they're running for public office, if they're serving as a officer or director of a for-profit entity, and if they're making a certain amount of money even if they're a non-for-profit director. If you have any questions regarding those topics or where to find that nifty chart, you can email us later and we can send that to you. Right now we are going on to things of value. I love talking about gifts. I often joke in the trainings, I don't know who is getting gifts. I have been a state employee for 14 years. No one's offered me a thing, but apparently it happens. And so that's why we have a certain section to talk about gifts and honoraria, and also travel reimbursement. Next slide. Here, again, you want to emphasize to your audience that what we need to think about when we're thinking about all these various topics is avoiding conflicts of interest. Next slide. And here are the steps that we'll go through in talking about our gift analysis. Step 1 is to define a gift. 2, we'll talk about the various gift exclusions. 3, identifying who is an interested source. It matters who the gift is coming from. And finally, is it a conflict? Is there an issue under Public Officers Law Section 74? Is that item or service being given to you as a reward for official action, or is it being given to you to induce you or encourage you to take certain action? And that's where receiving that gift or that item will be problematic. The first step in our gift area is to define, well, what is a gift? A gift is anything of more than a market value of $15. And under our regulations, anything less than $15 is what we call an item of nominal value. And those are generally going to be okay to take. A gift includes money, services, loans, travel, lodging, meals, entertainment, or any promise having a monetary value. And for example, a job offer can be considered a gift in some circumstances. Well, now we know what a gift is. The next slide, let's talk about what a gift is not. Under the regulations, and again, if you're new to this, we have all sorts of information on our website. The regulations have regulations at our website lists all of these, and I'm sure we have several different publications that talk about gifts. Excuse me. So we'll we'll rattle through this list quickly. They include awards or plaques, honorary degrees, promotional items, so that you can take a fistful of pens that don't work at the conference that you go to for work, widely available discounts, including, for example, you can give the example to your audience of the discounts for our cell phone carriers that are broadly offered to all state employees. Gifts from family or friends. Campaign donations are outside the definition of a gift. Meals and beverages at professional and educational programs. Professional and educational programs are also defined terms in the regulations. So if you're going to use this, if an officer employee has a question and says, hey, I'm going to this session offered by IBM and they are talking about a new product, well, that may or may not be okay for them to go to and take the meal and beverages. The definitions are really trying to get you to make sure you're not sending your employees to a sale pitch. Food or beverages worth $15 or less, and local travel payments. Next slide, we have a few more gift exclusions that are under the topic of an event. Informational events, so travel, food, lodging for speakers when that event is hosted by a governmental entity or an in-state accredited institution of higher learning. That's again, if you couldn't tell, a defined term. Also, you can take complimentary attendance, food and beverages at charitable events and political events, all defined in the regulations. The next slide. Another widely used gift exclusion is the widely attended event. And here's our little outline of the steps you need to go through to make sure that you're approving these in an appropriate way. The complimentary admission must be offered by the sponsor of the event, and 25 individuals who are not from your agency attend or are in good faith invited to attend. Basically, we want to see events that are not trying to hone in on one certain agency. And the event is related to your official duties or responsibilities, and that can generally be met by making sure that there's a speaker addressing an area of public concern and then it needs to be related to your employees' job duties. Or the event allows you to perform a ceremonial function appropriate to your position. When you're getting inquiries regarding these, make sure people are informing you in writing prior to the event taking place. I know sometimes you'll get word that the event is that night. It will serve you well to advertise or sing from the rooftops to make sure all your employees are coming to you with lots of advance notice. There are a couple no fun rules that Kate and I like to say. It makes it no fun, but there are additional rules if your people are going to attend these widely attended events. The food and the beverage is only permissible if it's offered to all participants. So they can't go off to a separate wine and cheese reception for people from their, for example, from only their agency. It also does not include entertainment, recreational, or sporting activities. The rule does say, unless the presentation is given during that entertainment or recreational or sporting activity. We get funny questions about that every once in a while. So if you get a question about that, feel free to call us and chat it through, because we do get some interesting ones. The next slide is step 3. So who is it coming from? And if your item or your service, your gift is coming from an interested source, that's where it's most likely not going to be permissible to take. And an interested source is a person or an entity who is regulated by or appears before you or your agency, has contracts with or is seeking a contract with you or your agency, is a registered lobbyist or client, or the spouse or the minor child of a registered lobbyist or client. lobbying your agency, is involved in adverse litigation to your agency, and has received or applied for funds within generally the last 12 months, or is attempting to influence your agency in official action. So if it could be thousands of people or entities at any time, and encourage your employees to come to you to make sure that there's not something that they may not know that's going on with that particular entity at the time, to make sure you let them know that you're there to help guide them through this. All right, the next slide is our step-by-step analysis regarding gifts. Kind of puts all this in a nice conclusion. Is the item or service valued at $15 or less, or does it fall in one of those gift exclusions? If it does, so it's not a gift, it's an item of nominal value, or it's a gift exclusion, it's generally going to be okay to take. But we also have to remind them of Public Officers Law 74. Are there circumstances where, even if they're being given an item of nominal value, where it could, depending on who it is or what other circumstances might be present, if it's being given to them to reward them for an official action, or to try to have that officer employee take certain official action, then it may not be okay. On the other side, if we have an item that's $15 or more, so we're in the gift territory, or it does not fall into one of those gift exclusions, if it's from an interested source, then we're on that left side. Yes, then it's presumptively prohibited. There are not going to be many circumstances, we tell people in our own trainings, where it's going to be okay to take that gift. There's not going to be many circumstances where, if it's from an interested source and it's a gift, that it's not being given to you to influence you or take official action. And if it's not from an interested source, then ordinarily those are going to be permissible. Next slide, we have a few more gift rules. Gifts to third parties. If you cannot accept a gift, then you cannot redirect it to anyone else, including, for example, your spouse or a child, or you cannot even redirect that to a charitable organization. There's a rule regarding multiple permissible gifts. Depending on the circumstances, it may violate the Code of Ethics in Public Officers Law 74 by creating an actual and apparent conflict of interest. The example Kate and I often give in these trainings is, imagine you're an employee and you work beside a vendor every day, and that vendor takes you for a cup of coffee every day. And what if they did that every day for 6 months? That can add up, and it might create an appearance problem. So keep those sorts of situations in mind. The next slide will briefly run through honoraria. And what is an honorarium? This is when you get a payment or other compensation exchanged for a professional service or activity which is not part of your state official duties. The examples are giving a speech, writing an article, or being on a panel in a seminar or a conference. What do you need to know? These are the rules you need to know for honorarium. Advanced written notice is you must get advanced written approval by your ethics officer. So you all should be receiving these before your employees are asking if they can do this, write an article and receive compensation for that. Over $1,000 per year, that goes on financial disclosure statements. Certain faculty members of CUNY and SUNY and other specific titles are exempt from these approval procedures, because that's what they're expected to do. They are expected to write articles as part of their profession. Statewide elected officials and civil department heads cannot accept honoraria for speeches, and we require all agencies to keep the records for 3 years. Restrictions on honoraria, and these kind of flow through this whole kind of gift area. So this will sort of be the same for gifts, honoraria, and travel reimbursement. You may not use state personnel or equipment, use state funds, and you cannot accept payments from an interested source. So anything from an interested source is usually going to be not okay to take. All right. And we're almost done with my section. The final topic I'm going to address today is official activity expense payments. That's a mouthful, but that's what we all usually refer to as travel reimbursement. And what is an official activity expense payment? It's travel reimbursement by a third party when your state officer employee is traveling as a part of their state job. So remind them, we get a lot of questions, well, I can't travel for work, but the state's paying. Well, it's not when the agency is paying, it's when a third party is paying. And again, these requests should be coming to ethics officers in advance. Very similar to the rules of honorarium. What do you need to know? The mode of travel must conform to the agency's travel policy, cannot accept from an interested source. Over $1,000, those also have to be on your financial disclosure statements, and we have that 3-year records retention rule. And I think that's it. And I'm going to turn it over to Kate for the home stretch here.
Phew. So like usual, the CETC is big and it's covering topics that are not going to be super inherently interesting to the people that you're training, right? And and Megan just really waded through the weeds on a lot of that stuff. And that is going to be one of the challenges that you have as a trainer of this material, right? Like you don't want to put people to sleep. Yes, you have a captive audience. They have to be here, but you do want to try to make it relevant and interesting. So this course can be challenging in that regard. So this section, politics in the workplace, is actually one of those places where you can be a little bit more informal, a little bit more casual. I think most people understand the need to remain nonpartisan in the workplace. So this next section of the training course doesn't have to be big or heavy. You can kind of land on the topics lightly and just keep it moving, because at this point people are going to be a little bit tired and tuned out. So, all right. So, but the main idea here is that we are all obligated to avoid politics in the workplace, and so that's what this section's all about. Now, we define what political activity is. I don't think anybody will need that, but political activity means what you think it means: doing anything in active support or opposition to any political issue or party or candidate or group, right? Big, broad umbrella definition. This is not one of those legal terms of art. And the best practice note that you see at the bottom here is really the main takeaway. If you are running short on time, you hit this and move on, which is that the main idea is that the state workforce should remain nonpartisan, and we really are obligated as people who are in service to the public to keep our personal political activities and opinions separate from the work that we do for the state. All right, that is the big picture. But there are a number of different laws that enforce that. There is Public Officers Law 73 that makes specific restrictions on our behavior. There are some provisions in Public Officers Law 74 that also restricts behavior. And there is also the Little Hatch Act contained in Civil Service Law 107. So there's a lot of different components of the law that deal with all of these various different restrictions. We've grouped them all together in this one section so that you can have one topic, one conversation, and then move on. So in Public Officers Law 73, there's two provisions, 16 and 17, that says that we can't, as a state employee, we can't be involved in awarding any grants or contracts to somebody that is linked to any kind of political coercion there. So we can't ask that contractor to disclose their political party affiliation or who they voted for or who they contributed for. So all of that grants and contracts has to be kept nonpartisan and clean. And when you're doing hiring for new employees, of course, you can't ask a prospective employee about their political affiliation and who they voted for and all that kind of stuff, right? Most people would expect that kind of thing. So now here, this section relates to the Little Hatch Act, Civil Service Law 107. And this is a much more broad laundry list of prohibitions that we can't we can't ask prospective job candidates about their political affiliations. We ourselves as employees can't be asked about our political affiliations. We can't use our state position to kind of coerce anybody to make any kind of political determinations. And we can't use our clout in order to in exchange for any political actions, that kind of stuff. And this also governs the fact that we can't use our state workplaces to solicit political contributions. So it says about what you would think it would. And then this final slide relates to specific provisions under the Code of Ethics in 74. So this would additionally prevent us from using our office to circulate a nominating petition or using any state resources for any kind of political activity, including using our email address to forward or engage in any kind of political communications. And we can't use our state computer or the internet connection to engage in any kind of political campaigning. So I've never yet had a single participant in 8 years of training the CETC ask any questions or wonder about any of this. This is all very common sense and well-known territory for most participants. But since this course is now required for brand new hires, that's the one place where I would say, don't skip over this entirely. A brand new hire may not immediately know all of these things, but even so, I think that this is going to be like the easier part of the course to train because it's common sense to most. Now, post-employment restrictions, though, this is where you might need to slow down and explain things to people because there's a lot of employees who are completely unaware that there are restrictions on our post-employment activities. So this is a place where you might want to get their attention by saying, listen up, this stuff may be important to you. All right, so what are the employment restrictions? We start here, we've kind of rejiggered or rearranged them here. So we start with the revolving door restrictions, and it's helpful to explain to people the purpose behind employment post-employment restrictions. And the whole idea is that the public, rightly or wrongly, has the idea that people are entering state service in order to gain important insider information, which they then go into the private sector and leverage. You know, all of their the insider information that they gain from the agency they can use in the private sector. So that's what these restrictions are designed to prevent. There are two kinds of restrictions, the 2-year bar and the lifetime bar. Between the 2-year bar is the one that's more commonly applied. The lifetime bar is very rarely applied. So if you are running short on time, the 2-year bar is where you want to spend more of your time. So what this does is it creates a cooling off period of 2 years when somebody leaves your state agency and goes into the private sector with a company that is doing business before their former agency. That's when this restriction applies. So the goal of this 2-year cooling off period is to prevent those employees from trying to influence their former agency in any kind of decision or action, or from going back to the former agency and talking to their former colleagues and getting information from their former colleagues that they would not be able to get as just a regular private citizen. All right. So that's the goal for this legislation. Now, this 2-year bar has 2 specific types of restrictions, but they're really 2 sides of the same coin. There's the appear and practice prohibition and the backroom services prohibition. And just note that this 2-year cooling off period begins when the employee leaves their agency, not when they join their state job. Okay, so the first appear or practice prohibition says that you can't appear or practice before your former agency for a period of 2 years. But especially in this day of COVID and remote everything, appear or practice does not mean physically showing up and appearing at your agency. It can be remote appearances. That's totally fine. It doesn't even need to be you showing up on a conference call. It could be any work product that you prepare in your new private sector job that you can reasonably foresee would be submitted to your former agency. So appear or practice, that is a legal term of art. It's a very broad term, and it means more than just physically showing up in front of your agency. Now, the flip side of that is the backroom services. So these former employees can't actively submit job products in front of their former agency to influence them, but they also can't work with their new colleagues in the private sector to develop some sort of plan to influence the former agency. That's the backroom services. They can't behind the scenes be strategizing and using that inside information in order to help their new private sector employee gain an unfair advantage in the private sector based on your insider knowledge. All right. So this applies only to paid work. You can do certain backroom services on a volunteer basis, but if you get an employee who is splitting those hairs, by all means seek guidance from the commission about how those apply. All right. There we go. Now this slide is all about chamber employees. This may not apply to many agencies, but some agencies do have employees who are also associated with the chamber, the executive chamber. So if you know you don't have any executive chamber employees in your session, you can say, and there's more restrictive rules for chamber employees, and then skip it. But if you have chamber employees, you may want to explain a little bit more. They just have a more expansive prohibition because executive chamber employees could potentially be interacting with all agencies, so they can't appear or practice before any state agency, not just the chamber, but they have a little bit more latitude with jobs that allow them to do backroom services. So chamber employees definitely need to seek guidance for post-employment restrictions. All right, so that's the 2-year bar. The lifetime bar is much more rarely applied. As it says, it's narrowly applied. It's very situationally specific. So we would need to have employees seek guidance if they're concerned that a lifetime ban may apply to them. There are a lot of different considerations that would be considered before applying a lifetime ban to somebody. And we list them out here, and this is a wall of text where mostly we have stripped text from the slides. So you can just kind of paraphrase this and just use this as a case example and say, and as you can see, the commission would look at a lot of different things before applying a lifetime ban to your situation. The lifetime bar is very narrowly applied, and then you just move on. All right. Now, there's a couple of post-employment restrictions related to negotiating future employment. If you have an employee who is working with outside vendors and they want to, apply for a job with that vendor, or if that vendor offers them a job, this is where this data applies. They can pursue a job with a vendor that's doing business before them, but they have to utterly recuse from doing any business with that third party for a 30-day cooling off period before they start negotiating that job with somebody else. So they have to recuse, they have to contact the ethics officer about that just to make sure that this job offer is not some sort of backdoor effort from that private sector agency to kind of scoop employees and gain that insider information. There are some exemptions to the post-employment restriction. These have not changed. But there's a government-to-government exemption. So if you have employees leaving state service, but they're going to another state agency, then these restrictions don't apply. Or if they move into a federal position or to a county level position, they're still public servants, and that exemption or that restriction goes away. That's an exemption. Also, if you work for a healthcare service provider, people can still continue to care for patients that they had cared for as a state employee even after they leave state service. And this last, the certificate of exemption, is there if an employee leaves your agency, but then the agency decides, oh dear, we really can't finish that project without Jane Smith. So Jane Smith can get hired back as a consultant to work with the agency to finish up a project. Technically, the post-employment restrictions would prevent that. So there is an exemption process if an agency decides they really need to hire back an employee as a consultant in order to finish up something specific. All right, so that's the post-employment restrictions, and then we bring you into the final landing with a brief discussion about ethics for all of us. So for those of you who have trained both the CETC and the ethics seminar, the previous refresher course, you'll maybe recognize the graphic here. But this is where we kind of pulled in some of the language from that ethics seminar and included it here in the CETC because we felt it really was important to remind employees why we're doing this ethics training to begin with. And the idea that we are all public servants, and as public servants, we are held to much higher standards of accountability than people who are working in the private sector. That public optics test that Megan went over when it's part of the code of ethics, in Public Officers Law 74, the fact that we are held to standards of accountability that the public has scrutiny over our conduct really places our service on a much higher standard than people in the private sector. And I think that's a point of pride. So public service is a public trust, and we are expected to serve the public interest. And this is where you can hop up on your soapbox and kind of make the case that public accountability is a source of pride, right? And then we just had to fit it in somewhere. We don't like to, make a real big deal about investigations and enforcement. It scares people off and it doesn't apply to most people, but we are known as the Ethics Watchdog Agency, and investigations and enforcement is part of what we do. But you can just reassure people that there are no secret proceedings, that we notify people if they are under investigation. We give them an opportunity to respond and provide their own perspective on things. And if they want to know more about how investigations and enforcement goes, all of our enforcement procedures are available in full on our website. We just mainly reassure people. That's what training is all about, is to avoid this outcome, right? And we also have to notify people of penalties. So there are civil penalties associated with violations of the various aspects of the Public Officers Law, but there are also agency penalties that can be imposed for violations. And as Megan mentioned earlier, the new Executive Law 94 that creates this new Ethics Commission has also given us a new enforcement tool, which is beyond being able to assess a civil penalty for a violation. In addition to or in lieu of civil penalty, our commission can also refer somebody back to the agency for agency discipline. So we might not assess a penalty, or maybe we will, but we also recommend that the agency terminate somebody. We didn't have the power to even recommend that anymore or previously, so that is something new. I don't know how that'll look. It hasn't happened yet, but that is a new compliance component that wasn't in our bag of tricks previously. All right. Now, we end with encouraging people to reach out for help when they need it. So we refer people first to their agency ethics officer, and that is primarily because the agency ethics officer, you, are in the best position to know what additional policies may apply to the employee. Our attorneys of the day know what the law is, but we don't know what the agency policies are. So we really do encourage all staff to go to the ethics officer first for the best source of guidance, but we are always willing and able to talk to employees individually through the Attorney of the Day program. They're busy folks, but they do a great job. And for employees who really are self-directed, you can send them to our website. It is huge and it's filled with a ton of information, way more than most people ever would need. But if you have some insomnia, I would say ethics.ny.gov is a really great place to start. All right. We also encourage everybody to use our tip line. If you see something, say something. So this hasn't changed. We still have it posted on our website, or you can call in to report a tip, either confidentially or anonymously. And then last slide, 72 slides. That's it. No longer over 100 slides, folks. So our last slide, like usual, has our contact information for the commission, our phone number, and our legal guidance number, and our website. So, whoo-wee, that is the new CETC. What I hope that you've seen for yourself now is that this is a lot more streamlined. It is fewer slides. The one place, though, that is the heaviest lift is the one slide, slide 23, that has the entire code of conduct, all of the different 9 standards of conduct on one slide. So we did a dry test run of this course material, and we were able to finish this in 90 minutes or less, which is great. That's what we were aiming for. Under the old rules, the CETC was required by law to be a 2-hour-long class. We no longer have a time restriction, so we did trim this down. We think that you can do this class in 90 minutes. If you can do it in less time, good for you, but it may take you longer depending on how many participants you have and how many questions that they ask. Now, somebody asked, is there a suggested class size? So I will speak to that. The law does still have this language that says that this live class needs to be interactive and participatory. Now, the way that the commission's predecessor and now have always interpreted that is interactive and participatory means that they have to have the ability to ask questions in real time. So as long as your participants have some way to ask questions, we think that the interactive and participatory standards are met. And I understand that that is not as an educator, that is not necessarily a great standard, but the simple truth is that the larger the class size, the less interactive you can make a class. So class size is going to depend on you, your agency, how many people you have, and the tools that you have available. WebEx can hold up to 500 people in a class, but can you really field questions from people if there are 500 people in the text chat? I know that there's been over 200 people, about 215 people today, and I know that I haven't been able to keep up on the questions. So class size is something that you're going to have to adjust for yourself.
Kate, I'm just going to jump in. This is Megan, everyone. I think what we'll probably do, because you all were just, firing them off. Boom, boom, boom. I think what we'll probably do is try to put them all together in the things we didn't answer today in an FAQ. And Kate and Brianna and I have been talking about doing that anyway for you all. So stay tuned. We'll take questions for a little bit longer as well. But I think the best way to do this is probably to get a written document together that you all can use and refer to.
Absolutely. We do have an FAQ that is under development. And one of the reasons why we didn't issue that FAQ yet, we've been working on it for the last couple of weeks, is because we knew that we were going to be getting more questions today, and we wanted to make sure that our FAQ was as responsive as possible to the wide variety of questions that you have. So please do continue to send us your questions. Now, I know that we've also gotten a lot of questions lately about the survey that we sent out and the data request that we sent out last week. So the overall comment for that is do the best you can with it. The data request only asks you, is basically asking you, have you done any training over the summer in July, August, or September? And if so, if you have, how many people fall into those basic categories? How many were your new hires? How many were FDS filers, and general totals? If you have not, in fact, conducted any training over the summer as you were awaiting further guidance from us, that's fine too. Just put in goose eggs and send it back to us. Manual training compliance reporting is a very difficult task, and it is just a first step, and we are going to be working on trying to streamline and produce compliance statistics that make sense, and it's going to just take time for that. The survey question, the survey is designed just to kind of get a sense of what are you currently doing in your agency as far as training. different agencies have different resources and different tools available to help them with these kinds of tasks. So in order for us to develop a training program that will be most responsive to the wide variety of circumstances out there, we're just kind of looking for what are you currently doing? What are the problems that you're facing? What resources do you have available? That kind of thing. So answer the questions as best as you can. If there's questions that you can't answer, that's okay. That is true for both the survey as well as the data compliance request. Do the best you can, answer it as best you can, as accurately as possible, without killing yourself about that. And we will continue to develop guidance about that as we go along.
Kate, let me speak to another question that just came in from my friend at DFS, Monica Marsh. I'm giving you a shout out right now. So she's asking any consideration for providing agencies with additional resources to assist with the expanded mandatory training requirement. That's a sort of a question in flux. As you all know, we're all been asked to keep most of us have been asked to keep our budgets flat. And so we're working with the transition team at the chamber to try to get some ideas of how to help agencies. This is we're all learning as we go. As far as Kate and I know, as far as the research I've done, there's never been a live training mandate for an entire state workforce. So, lots of states have statewide training for their officers and employees, but it might be an online course. I've never seen anything that's live for everyone. So we are taking it day by day, and as we learn more and as we figure this all out together, we'll give you the information that we can give you.
There are a lot of questions that are still to be determined. So I'll just address a couple of them. Our leadership has directed us to inform you to focus your training efforts first on new filers. Or not new filers, I'm sorry, new hires. I'm just so used to saying filers for training. So focus your efforts first on the new hires. We know that most agencies have really well-established routines for reaching out and contacting FDS filers. So if it is easily within your reach to continue to get your FDS filers into training classes, that's excellent. There are big questions about when do non-filers employees who are not new hires, right? People, just the rest of your staff who have been in existence, when do they need to complete training by? That is still to be determined. The legislation is very silent on some big pieces there, and our commissioners are very, very new. We haven't even finished getting all of the commissioners appointed to our board yet. So a lot of these questions that are burningly urgent for us who manage the training programs are just not even, haven't even been addressed yet by the commissioners because some of them haven't even been appointed yet. So I hate having to tell you we don't know answers yet. We are working hard to try to get answers to this and so many others. The basic answer is no, we haven't been given more resources. No, the state hasn't distributed more resources for agencies for this, but we are doing what we can to try to find solutions, ideas, and strategies to at least make what seems impossible possible. And I ask for your ongoing patience. I have to say, just personally and on behalf of my team, thank you very much. So many of you have reached out to us with words of encouragement for the daunting task we all have ahead of us. And so I thank you for that. And I thank you for your patience as we all work together to try to make this big, heavy lift happen. So, so last comments. I just sent to our web person all of the new training materials. So this course and the trainer notes, this full version, the CETC UPO and the trainer notes for that, the CETC NF for non-filers and the training notes for that, and the brand new revised plain language guide. All of those should be posted to the in the Train the Trainer section of the Ethics Officer Info Center, which you can find on our website under the Education menu. So go to Education, Ethics Officer Info Center, and then navigate to Train the Trainer, where you will find all of our course materials. It may take her a few days to get all of these materials formatted and posted, but by next week, all of these training materials should be available for your use. All right. So meanwhile, the next steps are I'm going to go through this chat in the next few days and beef up our FAQ. I think I'm going to include questions even if we don't have answers, so that you know that the questions didn't get missed. So please be patient with the questions that still get answered with to be determined. But other than that, we do have at least some tentative answers and things may change. That is my cat, Loki.
Sorry, everybody, that if you're not laughing.
And with Loki's say so, I am going to end this session. We ended early, which is awesome, but I am going to leave the webinar up for the next 15 minutes so that if you have additional questions that you would like to record in the text chat, that I invite you to do so that we can include those questions in the FAQs. So.
And let me end with one more thing too. I've gotten a lot of questions lately about, the gifts, the gift section and everything else. Just a reminder to everyone, and especially if you're a new ethics officer, that in most of these areas, you have the discretion as an agency to have stricter policies. So, for example, in gifts or outside activities, you can require all your employees to come to you for outside activity approval, even if they're a non-filer. Or for gifts, you can have a zero tolerance policy. I've just been getting a lot of questions lately regarding that. I thought that might be a good thing to slip in there at the end.
That's right. But you know what? We are all in this together. So yep. We're a resource for you, and we also utterly depend on you for hearing about what's going on in your areas. So keep the lines of communication open and stay tuned. Hopefully we'll be getting more comprehensive guidance out in the coming weeks. Thanks, everyone, and we will be in touch.